Good morning, Your Honors. May it please the Court, my name is Nick Brown. I'm with Carlton Fields, and I'm here today on behalf of the plaintiffs' appellants, Sarabay Marine Incorporated and P&D LLC. With the panel's permission, I'd like to save 4 minutes for rebuttal, please. Now, this is a legal malpractice action alleging negligent transfer by the defendant attorneys of over $4 million from their law firm trust account. The jury found that the lawyer was negligent, but that the transfer of the plaintiff's sale proceeds caused the plaintiffs no harm. The defense to causation was that no matter what, the money would have ended up where Mr. Greene transferred it, because that's what the plaintiff's principal, Ham Jones, intended and wanted. The problem was...
Sort of the way he ran these businesses, though, in his personal affairs. I mean, he had these corporations for these properties in this business, but he was just sold everything. Barring some of the things that you've raised, he certainly could have done that, couldn't he?
No question that he had the authority to do that, but it came down to a fact question at trial of what was his intent. And did his intent, in fact, conflict with the formal legal documents, the closing statement, and his estate plan, as the defendants contended?
Well, who resolves issues of fact, the court or the jury?
The jury resolves the issues of fact, Your Honor, but here they did that without the full picture.
Yeah, but Ms. Tromley was able to testify that his intentions were to leave money to the kids. She was allowed to testify to that.
That's correct.
So we have an abuse of discretion standard here, so we must find that no other judge would have excluded some of the evidence about his mental capacity and deterioration after October 7th. Nor would a judge have, excluded your special jury instruction, which was based on a federal bankruptcy case. So what happens in this case, because if you just read the briefs, you would think to yourself, wow, maybe they were prejudiced in some way, but I read 13,000 pages of trial. The plaintiff starts their opening statement by saying, this is about a dying man. Then the plaintiff puts on Mr. Greene, and they say, in his direct, he did not fit the bill as a normal client, did he? You were uncomfortable with him. Did you ever ask your partner about the effect of pain on a person's ability to comprehend? So this case from the get-go started out about his capacity, despite what the court had ruled, because the court said if Mr. Greene opens the door, you can get into this. Well, the plaintiff got into it anyway. So then when they put Ms. Trombley on, Ms. Trombley's allowed to testify he's so confused that Lorraine and I had an agreement we'd never leave him alone. He's hallucinating about, seagulls pecking at him. He's moaning and groaning. He has a profound memory loss. He has no short-term memory. He doesn't know where he is. He has difficulty communicating. And as of October 6th, according to Ms. Trombley, his responses were nonsensical and he couldn't make judgments and decisions. This all came in your case in chief. So how was the exclusion of the evidence that you wanted in after October 7th prejudicial? And how is that abuse of discretion?
I'm going to try to hit all that together. The first piece is that this is not, we contend, an abuse of discretion standard. The trial court made errors of law by ruling that this was excluded specifically because it was not pleaded in the complaint. The trial court ignored the reply that Florida law says is a pleading of equal dignity. And I can prove that with...
But the court allowed evidence of capacity, so now it becomes discretionary as to whether she allows more.
The trial court...
So she didn't deny it. She did not completely exclude this evidence. She made a decision and made a balancing. She actually balanced the evidence. So aren't we now dealing with discretion as to whether you allow more, as opposed to as a matter of law?
No, Your Honor. There were categorical exclusions here. The trial court excluded all expert evidence.
Which said that he was neurologically incapacitated based on review of records from 2013 to present, which would mean, if those records were admitted, Mr. Brown, that would call into question the validity of the sale itself. And that would call into question the issue of capacity that would require a battle of experts. And that's what the court was very, very concerned about. So you also were allowed, you're below, to show photographs of Mr. Jones from 2013 to late 2014, which obviously
That's incorrect, Your Honor.
a horrible... They were presented to witnesses. Ms. Trombley testified that that is not the same man. So you tried to show photographs of him as a hardy gentleman, and then you wanted to show photographs of him in a wheelchair.
We have not contested...
For what purpose?
I'm sorry, Your Honor. We have not... That wheelchair picture was the subject of a completely different motion that we conceded. We withdrew that evidence, and we never sought to admit it at trial, and it's not a part of this appeal.
But Dr. Susan Steen would come in and say within a reasonable degree of medical probability he's neurologically incapacitated.
And she
That has
agreed with...
far-reaching ramifications.
The defendant's own expert testified that Ham was cognitively impaired and that he may have been had dementia. So there's no disagreement between the expert in this case that Ham was cognitively impaired. The disagreement came down to the level of impairment. And the defendants argued in closing, knowing that they had excluded that evidence, their own expert evidence of incapacity. They argued that this was a trial strategy that we fabricated to make him incapable of understanding what was going on. Even if this was an abuse of discretion standard and it was just a weighing exercise, which we contend it's not, for multiple legal reasons, that would have been an abuse of discretion. This was rebuttal evidence that went to the heart of the main defense, where they said that Ham had the full intent and capacity to redirect this transfer differently from his formal documents.
But see, here's the tightrope that you're walking, and the court tried to provide you with a net, because the tightrope you're walking is you're trying to argue that he was incompetent and incapacitated to direct the money to his own account, but he was competent and had the capacity to direct it to the business accounts.
That's a great point, Your Honor, but the answer to that is there is no dispute from either party in this case that Ham wanted to sell the company's assets. He wanted to sell it for years. He had trouble finding a buyer. And so the decision to sell is separate from the decision of who gets the money. And here, the formal documents, they all suggested that it goes directly to the plaintiffs in this case, and that never happened.
What formal documents, sir?
He also had a plan for the money. He was going to buy a big boat and travel the world. I mean, how do we know that that plan didn't change? And certainly he would have needed the money to do that.
The evidence on that was conflicting, Your Honor. That testimony came from the person that ended up getting the money once Ham died. But remember, with respect to your question about the evidence on Ham's intent, he only sold the companies here. He didn't sell their assets. And his trust plan divided interests, percentage interests in those those companies to various beneficiaries, at the minimum suggesting that them companies would move on with that money and decide what to do with them.
But his estate plan wouldn't kick in and wouldn't be triggered until he died.
Or became incapacitated, Your Honor.
Oh, okay, so now we're getting back to the issue of incapacitation, which would affect the validity of the sale itself. But you didn't want to do that. See, this is what gets me about this case, is you're trying hard as you can, with all you have, to show he's incapacitated at this particular instant of time, but he's not incapacitated for the sale. When Dr. Steen's testimony is unequivocal that from 2013 he was deteriorating to the point of being neurologically incapacitated.
If we had tried to rescind that sale, Your Honor, we would have had to give the money back, but we never got the money. That's part of the problem at the issue in this case.
The way you're talking about, you weren't entitled to the money while he was still alive, were you?
Absolutely we were,
What shows that you're legally entitled to the money? Because Ham Jones is the trustee, the grantor, the sole owner, the sole officer, and your clients have absolutely no interest in any of these companies until he's dead.
Well, the clients are the companies, Your Honor, and it's undisputed.
They are now.
It's always been the case, and it's undisputed even by Mr. Greene that they owned the assets that were sold, and they also, as a result, owned the proceeds from the sale of those assets. This was undisputed at trial. The question came down to where was the money supposed to go. The closing documents, which Greene testified reflected Ham's intent, said that it goes to the sellers. And the estate plan said it does not go to Lorraine. And what ended up happening here was that it went to an account that Lorraine controlled because Mr. Jones was incapacitated, or at least had diminished capacity, and we were unable to establish that at trial because of huge swaths of evidence that were categorically excluded based on legal errors.
Yeah, but
Pleading analysis?
You introduced hundreds of pages of medical records, plus plaintiff's counsel on redirect intentionally asked Ms. Trombley what she meant by she could say about other reasons why she believes he's incapacitated, and she testified she had read 25,000 to 30,000 pages of medical records, which that is not the amount of medical records that was introduced in this case, which implies to that jury there's more to this. He's more incapacitated. So basically, you got your point across on redirect.
No, Your Honor, I would disagree. This was a lay witness talking about medical
A lay
expert.
witness who is his daughter, who's known him all her life, who is questioning defense counsel, who is opposing defense counsel's every question at every step, accusing Lorraine of answering all the medical records, accusing Lorraine of lying, saying that every entry in there was made by a nurse who didn't know her father, who didn't care about her father. She questioned every single record that showed that he was competent.
That's correct.
So then she was asked the ultimate record. What do you base that on? Well, 30,000 pages of medical records that weren't admitted.
Yes, Your Honor, that's true, but if I can respond to
So
that.
what's the implication to the jury?
Then that's exactly the problem, is that the implication was that they got to put on the evidence that they wanted to show that he was the man and in control, and we only got to put a sliver of the evidence on that challenged his intent at that period of time. It's excluded, and this goes to another point that you just asked about, Judge Sleet. They excluded the testimony of Ham's Home Health Aide, which was a health care provider that assisted him around the clock after the second amputation.
I understand that, but that doesn't have any relevance to what Mr. Greene knew at the time of closing.
Right, which is a separate question.
So that would do nothing but sympathize, cause sympathy for this jury.
No, Your Honor, that...
Because Mr. Greene didn't know about it. All Mr. Greene knew was what occurred up to October 7th. Correct?
Pardon?
Correct?
I don't know what Mr. Greene knew, but I think that sounds correct. But these are two different issues, Your Honor. The question of what Mr. Greene knew went to the question of negligence, of the question of breach. The question of where was the money supposed to end up, were the plaintiffs harmed by never getting their money, was a different question, and that's based on whether Ham actually changed his mind and decided that the money should instead go to the personal account.
Okay, well, let me ask you this, because this was introduced and there was no objection. It was your own expert, Mr. Aaron, who said he was posed the question. Mr. Aaron, assuming that Mr. Greene did what he was supposed to do, according to your opinions, can you honestly say that the result would have been different? And he said, no, I cannot.
That's correct. He's a
So
standard of care
the jury heard
expert.
that was admissible evidence. So why can't the jury have said to themselves, Mr. Greene, you were negligent. You didn't do what you were supposed to do. But guess what? We believe Ham Jones was going to do that anyway.
That's what they found, apparently, but
So
the problem
how's that
is
error?
the jury's finding must be made on proper evidence and proper instructions. And here, the court made legal errors in excluding this evidence. It did not exclude it on a 403 analysis. It excluded this evidence on its pleading analysis that it wasn't raised in the complaint. The court also excluded all after evidence. Even the cutoff ended before the transfer at issue, despite settled Florida Supreme Court precedent saying that both before and after evidence is relevant and admissible to establish mental capacity on a given date. That is a legal error. The court did not make a 403 analysis here. Any statements to that effect are based, in the first instance, on its pleading analysis. And I'd like to quote the trial court from the very last day of trial that proves this point. After we proffered our expert testimony and we proffered the testimony of Ham's home health aide, who said that shortly after the transfer, Ham didn't even recognize his own home, the court, and we asked that the door was opened and asked to admit this evidence, the trial court said, quote, not to keep repeating myself, but just so we're clear on the record, reviewing the operative complaint and what has been alleged as the negligence as it relates to Mr. Greene in this case, I remain with my original ruling, and even with the evidence that's been presented, I still believe that going into extrinsic evidence of capacity would go outside what's within the operative complaint. That's page 13002 of the record. That is not a 403 analysis. This is a de novo review, and it was error as a matter of law.
Yeah, but you're saying it's an error as a matter of law because she only let in a little bit of evidence, not all the evidence you wanted. That doesn't seem to be a matter of law. That seems to be an abuse of discretion type issue.
Even if
Because
it was...
it's an evidentiary decision. It's an evidentiary decision. She did allow that in. Actually, the plaintiff took a little bit of advantage of it because they hit it right from the get-go by saying he's a dying man. What does that have to do with this attorney's negligence? Unless you're trying to convey to this jury from day one, as soon as you snap the ball, that this guy's incompetent. And that is your theme throughout, and that appears to be what it was. But as I said, you're walking a tightrope because you're trying to convey to this jury he was incompetent to make the decision to keep his own money and put it in his own account with his wife that nobody else liked. That was obvious. But yet he was competent to send it to the businesses.
Because nobody contested the sale. He wanted to sell their assets for years. But even assuming, Your Honor, for the sake of argument that this is an abuse of discretion standard, it was absolutely an abuse of discretion for at least two reasons. One, this was relevant rebuttal that was pleaded. It was admitted to be pleaded and relevant, and it went to the heart of the causation defense of what was Ham's intent. And two, the defendants, at least twice, two of their witnesses opened the door. And under Judge Morris's decision in Pelham and the First District's decision in Ryder, once that door-opening testimony came out, any of the times it did, the in limine ruling became a nullity, and we were entitled to rebut that. And that didn't happen here. The defendants were allowed to paint a rosy picture of a dead man and his intent, and we were precluded from rebutting it. And then in closing argument, they pointed and said we made the whole thing up. They attacked our lay testimony about medical records and said that the healthcare providers were more credible, even though they had excluded the home health aide, who was a disinterested witness and was with Ham first, round the clock, firsthand, and would have testified that just after the transfer, Ham didn't even recognize his own home. The court excluded evidence from 4 days after the transfer that Ham couldn't consent to his own medical care because Lorraine said he was too confused to do so. So it would have been an abuse of discretion at any of these points,
Well, let's balance that testimony with the testimony of Mr. Tosian on direct when he was asked about a guardian. And you only get a guardian for an incapacitated person. So you were allowed to, or your colleague was allowed to delve into this issue of a guardian. And it's pretty common knowledge that a guardian is for an incapacitated person. Your expert said that about the propriety of appointing a guardian. So you basically got an incapacitation in. And the trial court allowed Mr. Tosian to testify that Greene should have consulted with the family and the doctors before wiring the funds to see if he was too impaired. So it appears to me that you got it in, and you got it in through an expert.
We were allowed, Your Honor, to address the issue of capacity, but the court ruled we were expressly prohibited from trying to establish his incapacity. We were only allowed impeachment evidence, and only then lay evidence, and only then from a window that excluded even the date of the transfer itself.
A guardian has a higher legal status than a home health aide that you wanted in.
These are fact issues, Your Honor, that should have gone to the jury.
For the jury to resolve.
That's absolutely correct.
And the jury heard it.
The jury only heard a sliver of the evidence, and it was presented with a misleadingly positive picture. And that picture was because the trial court's legal rulings constrained the presentation of evidence.
Mr. Brown, you've been peppered with a lot of questions, but you're up to 18 minutes.
I'll reserve my time for rebuttal then. Thank you.
Thank you, Mr. Brown.
Good morning. May it please the court, I'm C.C. Berman, here today on behalf of the appellees, attorney Robert Greene and his law firm, Greene, Hamrick, Perry, Quinlan, and Shermer. So I'd like to take a big step back for a moment. Although, Judge Sleet, you were hitting the nail on the head over and over with the questions that you were raising. But the step back I'd like to take, too, is to remind this court, we talked all about estate planning and everything else. This is a legal malpractice claim about a real estate closing that is somehow being turned into a claim where these folks don't have a claim through the estate, through the probate process, so they're trying to sue this lawyer for legal malpractice who handled the real estate closing on behalf of Ham Jones and Ham Jones's entities. And the bottom line is we keep talking about causation defense. Did Mr. Greene and his law firm have a defense? Absolutely, he did. And absolutely, one of the things they argued was that Ham Jones had the authority to send this money wherever he wanted to send it. But at core, the plaintiffs have the burden to prove causation in this case. That's the bottom line. And they could not do it here. They had none of these discretionary trial court evidentiary rulings we're talking about have any bearing on whether the plaintiffs could have or did carry their causation burden at the end of the day.
Didn't Mr. Greene have a duty to determine whether Mr. Jones was competent to make these decisions?
You know,
At the very least.
for argument's sake, let's assume he did. Here's the problem as we talk about all this mental capacity evidence. Before we even get to what Your Honor was talking about earlier, where this was all fully explored by the jury and heard. And certainly, I mean, they heard he was hallucinating and this, that, and the other thing. There was no rosy picture painted. But at the end of the day, all this capacity evidence goes to the duty and the negligence question, and guess what? He was found negligent. So obviously the jury heard it, and obviously maybe they took something from it. They found that Bob Greene didn't dot his I's and cross his T's in this case, because remember the two negligence theories were he was failing to communicate to Ham Jones that Ham was wearing all these different hats, that Ham was in one hand, acting as his sole trustee and also acting on behalf of Sarabay and also acting on behalf of P&D, and he should have been advised about potential conflicts of interest. Bob Greene, that was one theory of negligence, and the other was that Bob Greene shouldn't have transferred the sale proceeds to Ham Jones's personal bank account. That should have gone into Sarabay's. And if Ham Jones wanted to go to the personal account, then he needed a corporate resolution, some kind of written authorization from Ham on behalf in his role for Sarabay instead of Ham in his role for himself.
So Ham needed to consult with Ham to get Ham's permission.
Exactly, Your Honor. That's exactly right, and that's exactly the theory of negligence. But you know what? The jury bought it, and that's fine. I mean, let's take your...
But what about Mr. Brown's argument in terms of their clients were legally entitled to those proceeds?
Your Honor, I think you addressed this when you were talking. The trust agreement, that didn't kick in until Ham Jones was alive. Ham Jones was alive for 4 more months after the sale, and frankly, although he was in ill health, most of us don't think we're about to die. I mean, so the trust agreement talks about, I think, and I have it for you, the record page is 5296. That's where you can find the Sixth Amendment to the trust. And if you look at 3.4, what that appears to be talking about is Ham Jones has been trying to sell this property. So in 2010, he amends his trust agreement because if something had happened to him and the property hadn't been sold, let's say he had died, then Lorraine and his accountant, who would become the successor trustee, would manage Sarabay and P&D, and then once the property got sold, then Gary Trapp, the successor trustee, would handle the funds, and the funds would get dispersed out, and there's details in there about who gets what and how it all works. But Ham Jones never died yet at the time this happened. So this was Ham Jones's money, Ham Jones's company's money, of which he was the sole member, sole trustee of this revocable trust, where he was the sole beneficiary, sole trustee, sole everything. And at the end of the day, he had every right to do whatever he wanted with his money. And they had to prove that Bob Greene somehow, somehow could otherwise do anything differently. That was something that, but for Bob Greene's negligence.
He followed the transaction with a phone call to his bank to alert them.
Before the transaction, actually, Your Honor.
Before?
Yes. So the bank manager has no.
He said, hey, this money's
Mm-hmm.
coming.
Yeah. So Ham Jones calls the bank manager in what I'll call the relevant time frame where the court did allow all this capacity evidence. This person has no interest in anything, and this bank manager says, yeah, I got a call from Ham Jones. Ham Jones has been working with all these folks for years. Bob Greene had been his real estate attorney for 20 years. He'd been dealing with the bank manager forever. The bank manager knew what Sarabay was, what P&D was, knew that P&D stood for property next door. I mean, these were folks that Ham just dealt with all the time. And Ham calls his bank manager and says, before the transaction, hey, there's going to be a big wire coming in to my checking account. Would you monitor it for me, please, and let me know when that comes in? And that's in the record, page 12,099. Abby Crawford testifies to that. So yes, Ham Jones let the bank manager know that this was occurring. So at the end of the day, Your Honor, getting back to duty, did Bob Greene have a duty that he violated? I think we can just assume for purposes of this argument today, yes, and the jury found that. The jury found Bob Greene negligent. But the problem is that the plaintiffs still had to carry their burden at the end of the day to show that something would have been different. And anyway, let's talk about the capacity evidence. Let's just go straight into it, and let's talk about whether that mattered and what the deal really was here. As Your Honor pointed out, what's getting a little confusing about this whole thing is, so practically, what are the plaintiffs, basically these holding companies that no longer hold anything, what are they suggesting? That Ham, after finally selling the property of years of trying to sell it, he had the ability to sell it, but he didn't have the ability to talk about where his money would go? Or was it that he had the ability to sell it and he had the ability to tell Bob Greene where the money would go, but Bob Greene just should have noticed that something wasn't, quite right, and Bob Greene should have taken a little bit more care? I mean, at the end of the day, what does any of that matter, and what does any of that change? I would submit, Your Honor, nothing at all. And this is all material the jury heard.
What would be the import of the other subsequent evidence of deterioration and incapacitation, including Dr. Susan Steen's opinions? What would be the import of that evidence?
That evidence,
if it came in?
Absolutely none, because we're a legal malpractice case about what Bob Greene knew or should have known, which is exactly the tightrope that they were walking, and the trial court tried very hard to balance. I mean, the trial court let in a lot within its discretion, as we've already discussed. And all of this stuff that happened after Bob Greene was done and handling the closing has no import whatsoever. And, the trial judge, you can see it in the record at page 13,505. He says, we're going to get into, and the jury's going to know, that Mr. Greene had to go to Ham's house because Ham had had an amputation, that Ham was somewhat non-ambulatory, that they had to stop multiple times because of pain, that the plaintiffs may or may not talk about these things, that he was on pain medication, and then the court goes on to do what the plaintiffs say it didn't do, which is a 403 discretionary analysis, because he talks about, for instance, this being confusing for the jury, which is a standard 403 analysis, and says, I don't want this trial to go off the rails, because going too far into capacity would confuse the jury. I've given the plaintiffs more latitude regarding capacity than I even could have. I don't want to have a trial where we are trying to establish if he had capacity or not, because it has to do, to your question, Judge Sleet, with what Mr. Greene was supposed to do based on the information he knew or should have known. There was no rosy picture painted. The plaintiffs even said, page 10,297 of the record, they wanted the jury to understand that Ham was a very sick man, not a cheery 80-year-old sitting in his recliner. I don't think that anyone who looks at this record could possibly think that the jury had that picture painted of Ham Jones, when in fact the jury heard about how he suffered from memory loss, experienced cognitive decline, expressed fears about dying, hallucinated while in the hospital. All of this came in, all of this was fully explored. At the end of the day, what this all comes back to is Ham Jones was alive. If he had the ability to close this sale, which the plaintiffs are certainly arguing that he did, and yes, he had the intent to sell it for years, but there's a lot more that goes into intent to sell it. You had to figure out how much it was going to cost, you had to actually go through the closing itself, how do you know Ham Jones didn't change his mind, et cetera, et cetera, et cetera.
Were there any allegations in the complaint of a failure to have a guardian appointed?
I have to be honest with you, I don't recall, Your Honor, with certainty, but I don't think so. I can't imagine. I feel like I would remember that, and I don't think so. And that's because the same tightrope they had to walk. This was the issue danced around the entire time. Somehow Ham Jones was able to close the sale, but he wasn't able to do what he wanted with his money. And I think the jury got it absolutely right. Maybe Bob Greene should have had a piece of paper from Ham as Sarabay saying that Sarabay could transfer it to Ham as Ham, and Bob Greene didn't do that. But at the end of the day, Ham is all of these things, as Judge Morris pointed out at the outset of appellant's argument. And so at the end of the day, there was no injury, and the jury understood very well. They heard all of this, and they understood what was going on, and they got it right, and they resolved all of these fact issues, and the trial court was very careful in its discretionary rulings and allowed in loads of evidence. Are there any further questions that I can answer for the court? Thank you so much, Your Honor. We'd ask that you affirm.
Thank you, Ms. Berman. Mr. Brown, a couple of minutes of rebuttal.
Yes, thank you. Mr. Greene's counsel just said that nobody thought that there was a good picture of Ham. Well, then why did they argue that in their closing? They said he was physically slipping, but he was not a man who was mentally losing his grip. That's what they said. That was knowing they had excluded their own expert testimony that he was cognitively impaired, and they accused the plaintiffs of fabricating the whole thing. I submit, even without regard to the legal errors before in the initial ruling excluding based on the pleadings themselves, not a 403 analysis, even aside from thereafter opening the door by express testimony by an expert and a lay witness after it.
On the contrary, you were permitted to show that Ham suffered horrible pain, suffered from memory loss, had experienced cognitive decline, had expressed fears about dying, and hallucinated while he was in the hospital. What more is there to show?
There's plenty more, Your Honor. All that came from an interested lay witness. We had expert testimony that would have given context to the medical records that were allowed, and it also would have explained that a hallmark of cognitive impairment involves not being aware of finances and giving them away in unusual ways. And
that certainly begs the question, Mr. Brown. I mean, it's not in the record or anything else, but curiosity's just killing me. Why didn't the family appoint a guardian?
I don't know the answer to that, Your Honor. It's not in the record.
The jury probably asked the same reason, because if Ms. Trombley's going to basically trash her dad and make him basically a deteriorating, incompetent man unless it favors her, but yet didn't get a guardian,
the expert would have
maybe they didn't believe her.
Your Honor, the expert would have testified if allowed, and I think this came out in our proffer. I'm not certain, but I believe it did, that even people that have severe cognitive impairment can appear lucid at times, and often that would occur when they're seeing family.
Well, then that would favor Mr. Greene's testimony.
That would favor
arguments that he had moments of lucidity.
That would only help on negligence, Your Honor. It's a separate question of what Ham intended for the money and whether he understood what happened. Remember, Greene never talked to him about where the money was going to go or its impact on the estate plan or its impact on the companies. And so even a general intent was not a knowing one, which is, even assuming he had capacity, which we absolutely contest. And none of that, all these issues, capacity bleeds over two different issues, but it bleeds in different ways. The negligence was, did Greene do the right thing? But the causation question was, what did Ham want? They said it didn't matter what Greene did because this is what Ham wanted. And we were precluded from establishing that Ham, challenging Ham's capacity.
Are you arguing that he had the competence to direct the money to the companies, but he didn't have the competence to take it back if he wanted to?
No, it was the company's money. There's no question.
Isn't that inconsistent?
I'm sorry?
Isn't that an inconsistent argument?
No, Your Honor, it's not. The money belonged to the companies. He would have had to have...
He owned the companies.
The trust owned the companies.
He was the companies.
No, Your Honor, he was not.
He's the trust.
No, Your Honor, that's contrary to settled Florida law.
He's the trustee.
He is the trustee. He had authority. We don't contest his authority.
And Mr. Tosian said he could do whatever he wanted with this money.
That's right. And the question was, what did he want, and did he have the the mental capacity to redirect the money away from the companies that owned it?
Thank you, Mr. Brown.
Thank you.
Thank you both. Our next case is Helms and Rizzi versus Wolf.